Indiana has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The governing framework includes Indiana's landlord-tenant statutes, found in Indiana Code Title 32, Article 31, along with FCRA and the Indiana Civil Rights Law. Indiana gives landlords broad discretion in the screening process, and the state has enacted preemption provisions that limit local governments from imposing additional restrictions. Let's start with application fees. Indiana does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Indiana's landlord-tenant statutes do not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Indiana landlords charge between $20 and $45 per applicant. Indiana's rental market is generally affordable relative to national averages, and keeping fees proportionate to actual screening costs is good practice. In competitive markets like downtown Indianapolis, Carmel, and Bloomington, applicants are accustomed to paying screening fees. In smaller markets across the state, keeping fees reasonable ensures you don't discourage qualified applicants. Criminal history screening in Indiana is unrestricted at the state level. Indiana does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. Indiana has a preemption statute, Section 32-31-1-20, that limits the ability of local governments to regulate certain aspects of the landlord-tenant relationship. This preemption has been interpreted broadly and effectively prevents Indiana municipalities from enacting local screening restrictions that go beyond state law. As a result, no Indiana municipality has enacted local criminal history screening restrictions for housing. Indianapolis, Fort Wayne, Evansville, South Bend, and every other Indiana community operate under the same unrestricted framework. This preemption is particularly significant because Indianapolis, the state's largest city and the most politically moderate of Indiana's major metros, might otherwise have enacted local tenant protections given the city's growing diversity and active housing advocacy community. The preemption ensures statewide uniformity. Indiana has provisions for expungement of certain criminal records under Indiana Code Section 3538-9. Indiana's expungement law, enacted in 2013 and subsequently expanded, is relatively comprehensive. Certain misdemeanors are eligible for expungement after 5 years, and certain felonies after 8 or 10 years depending on the class. Once a record is expunged under Indiana law, it is sealed from public access, and the individual can legally state they have not been convicted. Landlords cannot consider expunged records in screening decisions. Indiana's expungement law includes a unique provision. Employers and landlords who discover that an applicant has an expunged record and use that information against the applicant can face legal consequences. This creates an additional incentive to ensure your screening provider is properly filtering expunged records. If your provider returns an expunged record and you rely on it in your screening decision, you face potential liability. Indiana has not legalized recreational marijuana. Possession remains a criminal offense. However, neighboring states, Illinois and Michigan, have legalized recreational marijuana. Applicants relocating from these states may have marijuana-related records for conduct that's legal in their previous state. The weight given to minor marijuana records should be evaluated thoughtfully in this border state context. HUD's 2016 guidance on criminal history and disparate impact applies in Indiana. Indianapolis, Fort Wayne, South Bend, Gary, and other Indiana cities have diverse populations, and criminal history policies that disproportionately affect minority applicants face scrutiny under federal fair housing law. Indiana has significant racial disparities in its criminal justice system, and blanket rejection policies create particular risk in communities with diverse applicant pools. Documenting your criteria and applying them consistently is essential. Source of income protection does not exist at the state level in Indiana. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. Indiana's preemption statute would likely prevent local municipalities from enacting their own source of income protections. Participation in voucher programs is entirely voluntary. However, Bloomington, home to Indiana University, has been active in discussing additional tenant protections, including source of income considerations. While Bloomington may be limited by state preemption, landlords in Bloomington should be aware that the political environment supports tenant protections and community scrutiny of screening practices is higher than in other Indiana markets. For credit reports, Indiana follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Indiana does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond FCRA. Indiana's fair housing protections under the Indiana Civil Rights Law, found in Indiana Code Title 22, Article 9.5, prohibit discrimination in housing based on race, color, religion, national origin, sex, disability, familial status, and ancestry. The inclusion of ancestry goes slightly beyond the federal baseline. Indiana has not added sexual orientation, gender identity, marital status, age, or source of income as protected categories at the state level. The Indiana Civil Rights Commission investigates fair housing complaints and has enforcement authority. While the state law doesn't protect sexual orientation or gender identity, several Indiana cities have enacted local non-discrimination ordinances. Indianapolis, through the Indianapolis-Marion County Human Rights Ordinance, protects sexual orientation and gender identity. Bloomington has similar local protections. South Bend, West Lafayette, Evansville, and several other Indiana cities have enacted local fairness ordinances. Landlords in these cities must comply with the broader local protections. Screening decisions that appear to target applicants based on sexual orientation or gender identity can result in local enforcement actions. The interaction between Indiana's preemption statute and local non-discrimination ordinances is a nuanced legal area. The preemption has been interpreted primarily to prevent regulation of landlord-tenant financial terms, like rent control, rather than to prevent local civil rights protections. As a result, local fairness ordinances covering sexual orientation and gender identity have generally been upheld. Landlords should comply with local non-discrimination ordinances in the cities that have enacted them. From a practical standpoint, Indiana has a large rental market concentrated in a few major metros, with secondary markets scattered across the state. Indianapolis is Indiana's dominant rental market and the largest city in the state by a wide margin. The Indianapolis metro, including Carmel, Fishers, Noblesville, Greenwood, Lawrence, and Plainfield, has a diversified economy driven by healthcare, including IU Health, Community Health Network, and Ascension St. Vincent Pharmaceuticals. Eli Lilly's world headquarters, logistics. Indianapolis is a major national distribution hub, technology, motorsports, the Indianapolis Motor Speedway, and the broader racing industry, government, and higher education. Indianapolis's rental market is competitive with steady demand and moderate rents relative to comparably sized metros. Indianapolis has experienced growth and revitalization in several neighborhoods. Downtown, Mass Ave, Fountain Square, Broad Ripple, and the near North Side have seen strong demand from young professionals. The northern suburbs, Carmel, Fishers, and Noblesville, attract families and command premium rents. The southern and eastern parts of the metro have more affordable rents. Indianapolis's local fairness ordinance protecting sexual orientation and gender identity means that landlords in Marion County operate under broader fair housing protections than the state baseline. The Indianapolis-Marion County Human Relations Commission investigates complaints. Fort Wayne, Indiana's second-largest city, has a moderate rental market driven by manufacturing, including General Motors and Sweetwater Sound, healthcare, including Parkview Health and Lutheran Health Network, defense, the Fort Wayne area has defense industry operations, and education. Fort Wayne has a growing immigrant and refugee community, including significant Burmese and Hispanic populations. Screening applicants from these communities involves evaluating limited U.S. credit history and non-traditional backgrounds. South Bend, home to the University of Notre Dame, has a moderate market influenced by the university, healthcare, including Beacon Health System, and manufacturing. Notre Dame's enrollment creates some rental demand, though a larger proportion of students live on campus compared to many state universities. South Bend's local non-discrimination ordinance provides broader protections than state law. Evansville, in southwestern Indiana, has a moderate market driven by healthcare, manufacturing, and the University of Southern Indiana. Evansville has a local fairness ordinance. The city's proximity to the Kentucky and Illinois borders means some applicants may be relocating from states with different regulatory environments. Bloomington, home to Indiana University, has one of the tightest rental markets in the state relative to its size. IU's massive enrollment creates enormous student demand and seasonal turnover. Bloomington's progressive political environment and local protections create a more regulated screening landscape than most Indiana communities. Screening students with limited credit and rental history requires consistent cosigner or guarantor policies applied uniformly. West Lafayette, home to Purdue University, has a similar student-driven dynamic. Purdue's large engineering and technology programs attract students from around the world, and landlords screen a significant number of international students who may have no U.S. credit history, no social security number for screening purposes, and income supported by family or scholarship funding. Having clear criteria for evaluating international student applicants is essential for West Lafayette landlords. Gary, Hammond, and the Northwest Indiana communities in the Chicago metro area have markets influenced by proximity to Chicago. Many residents commute to Illinois for work. The steel industry and logistics drive local employment. Gary has experienced significant population decline and has soft rental markets in many neighborhoods. Screening in Northwest Indiana requires realistic criteria calibrated to the local market. Terre Haute, home to Indiana State University, Muncie, home to Ball State University, and Anderson have moderate to soft markets driven by their respective universities and manufacturing. These communities have experienced economic challenges and population stagnation. Military presence in Indiana is moderate. Naval Support Activity Crane, commonly called Crane Naval Weapons Center, in southern Indiana generates some rental demand in the Bedford and Bloomington areas. Camp Atterbury near Edinburgh is primarily a National Guard training facility. Grissom Air Reserve Base near Peru has limited active-duty rental demand. Landlords near these installations should understand military income documentation, but the impact on the overall rental market is modest compared to states with major active-duty bases. One best practice for Indiana landlords: verify that your screening provider properly filters expunged records under Indiana's expungement law. Indiana's statute specifically creates liability for landlords who discover and use expunged records against applicants. If your provider returns an expunged record, you have a problem, both because you received information you shouldn't have and because acting on it exposes you to legal consequences. Ask your provider specifically about their compliance with Indiana Code Section 35 to 38(9) and how they handle expunged records. Another best practice: determine whether your property is in a city with a local fairness ordinance. Indianapolis, Bloomington, South Bend, Evansville, West Lafayette, and other cities have local protections covering sexual orientation and gender identity. Build your screening process around the broader protections applicable to each property's specific location. If you own properties in both Indianapolis and a smaller community without local protections, be aware of the different requirements. A third best practice: for landlords in Bloomington and West Lafayette who screen high volumes of student applicants, including international students, develop a clear and documented process for evaluating applicants with no U.S. credit history or limited rental background. International students may not have Social Security numbers, may not have U.S.-based credit files, and may rely on family funding or scholarships rather than personal employment income. Having a standardized alternative evaluation process, such as accepting international cosigners, requiring prepaid rent, or evaluating scholarship funding documentation, ensures you can process these applications consistently and fairly. Indiana does not have a statutory cap on security deposits. The deposit amount is governed by the lease terms, giving landlords flexibility. The deposit must be returned within 45 days of the tenant vacating, along with an itemized statement of deductions. While the flexibility on deposit amounts provides financial protection, thorough screening remains the most effective tool for tenant selection. No deposit amount compensates for the cost and disruption of evicting a problem tenant. For the complete guide to Indiana tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.